Hello, good evening all. Welcome to another video with Pratham Test Prep, and today we'll be discussing the Parliamentary Standing Committee's response on India's new criminal laws. So in August 2023, the Union Home Minister introduced 3 new bills in the Lok Sabha that proposes a complete overhaul of the country's criminal justice system. So these 3 bills are Bharatiya Nyaya Sanhita Bill 2023, which will replace Indian Penal Code 1860, the Bharatiya Nagrik Suraksha Sanhita Bill 2023, which will replace the CRPC, and the Bharatiya Sakshya Bill 2023, which will replace the Indian Evidence Act of 1872. Now, these bills were referred to the Standing Committee on Home Affairs on the August of 11, 2023, and the Standing Committee on Home Affairs, which was chaired by Mr. Brijlal, submitted its report on all these 3 bills on November 10, 2023. Now, talking about the first bill, that is Bharatiya Nyaya Sanhita, which will be replacing IPC. So let's have a look into IPC. So before we continue any further, there has been a video which has already been made in detail regarding what recommendations and what are the new additions in Bharatiya Nyaya Sanhita with a comparison to the old IPC. So you can watch that video. But to give you a brief, the Indian Penal Code of 1860, a cornerstone in India's legal framework, continues to play a pivotal role in defining and categorizing criminal offences. It was enacted during the British colonial rule, and the IPC covers a spectrum of crimes, prescribing punishments and upholding principles of justice, addressing offences against person, property, public order, morality, decency, religion, and the state. It remains relevant through the amendments and modifications. Despite its historical origins, the Indian Penal Code remains a crucial legal document guiding India's criminal justice system, ensuring the investigation, trial, and punishment of offenders while adapting to contemporary societal norms. Now, talking about the Bharatiya Nyaya Sanhita 2023, which was introduced in Lok Sabha on August 11, 2023, which aims to reform the criminal justice system in India by replacing the Indian Penal Code of 1860. So the notable changes include the removal of sedition, introducing new offences related to secession and terrorism, and addressing organized crime. The bill prescribes severe penalties for terrorism, including death penalty or life imprisonment, and introduces penalties for organized crimes and petty organized crimes. It also establishes separate penalties for murders based on caste or race, and extends the death penalty for gang rape of minors, and penalizes sexual intercourse by deceitful means. The bill also expands the scope of certain offences to include boys, and overall presents a more modern and comprehensive legal framework. Now, the Standing Committee, what are the suggestions of the Standing Committee on this particular on your Bharatiya Nyaya Sanhita 2023. First of all, the Standing Committee recommended retaining sections on adultery, acknowledging the importance in Indian society, and also suggested including section 377 from the IPC to penalize non-consensual sexual offences. It advised reverting to the term unsound mind instead of mental illness in cases where the acts by a person with mental illness are not to be considered offences. The committee also proposed separating the offence and attempt to commit organized crime, widening its scope by changing group size requirement. It called for clarifying the vague term general feelings of insecurity in the definition of petty organized crime. The committee also recommended defining intimidation in the context of terrorism to avoid ambiguity, and sought clarification on the term of community service as a form of punishment as well. Regarding causing death by negligence, the committee suggested limiting the provision to motor vehicle accidents to avoid violating the right against self-incrimination. For murder by a group, it recommended consulting legal experts to potentially delete a specific imprisonment duration. Dissenting members noted similarities with existing laws, concerns about Hindi-only names violating the constitution, and insufficient consultation with experts and the public. The recommendation included deleting the provision of solitary confinement, decriminalizing adultery, and requiring recorded reasons for government commuting sentences. But the last 3 suggestions, they are the dissenting suggestions, so they will not be taken into consideration. Now let's talk about the next important law, that is Bharatiya Nagrik Suraksha Sanhita Bill 2023. Now again with your Bharatiya Nyaya Sanhita, it was introduced on August 11, 2023. Now it replaces the Code of Criminal Procedure 1973. So talking about Code of Criminal Procedure, it is a comprehensive legal code governing criminal procedures in India. It was enacted to consolidate and amend criminal procedure laws. It applies nationwide and covers arrest, bail, investigation, trial, appeal, evidence, judgment, and sentencing. The CRPC ensures fair trials, protection of rights, and outlines procedures for magistrate, warrants, and summon. It also addresses juvenile justice and the maintenance of public order, playing a crucial role in the Indian criminal justice system. Now, talking about the Bharatiya Nagrik Suraksha Sanhita Bill 2023, which will be replacing the current Code of Criminal Procedure 1973, while preserving in this particular Act, while preserving key elements, the bill introduces noteworthy changes, including allowing electronic trials and expanding the range of offences requiring forensic investigation. It modifies provisions related to under trial detention, enabling release on bail for the first time offenders after serving 1/3 of the maximum sentence. The bill also empowers any police officer to request a medical examination of the accused and grants metropolitan and judicial magistrates broader authority to order specimen signatures, finger impressions, and voice samples. Now, specific timelines for procedures are also introduced, and trials can proceed in the absence of proclaimed offenders for serious offences. The bill eliminates the provision of designating metropolitan areas and magistrates based on population size. Overall, if we see, the legislation aims to modernize and streamline the criminal procedure in India. Now, let's talk about what has the committee suggested and what has the standing committee report has found out. So, the committee recommended alterations, including empowering subordinate officers to investigate grave offences. So, while the new bill grants any police officer the authority to investigate cognizable offences within their jurisdiction, the committee suggested, especially for serious offences, that subordinate officers should handle investigations instead of superintendent of police, taking in consideration the work sphere of the superintendent of police and how he is supposed to take care of the whole city. So regarding under trial prisoners, the bill introduces modifications to CRPC by excluding certain offences and individual with pending proceedings from the provision requiring release on personal bond after serving half of the maximum imprisonment period. Now, the committee proposes that under trials be granted bail after serving the maximum sentence for the most severe offence, excluding cases with consecutive sentences. There have been changes made to the under trial release conditions that were suggested by the committee, and concerns were also raised about potential misuse of the 15-day detention period clause. The incorporation of audio-visual recording with the safeguards and addressing terrorism and organized crime procedures were recommended by the committee, and the amendment allowing life sentence commutation prompted a call for specifying both minimum and maximum sentences. The dissent notes again in this particular for this particular bill again highlighted that the Hindi only names are violating the constitution and there has been an insufficient public consultation. Now let's move on to the next bill, that is Bharatiya Sakshi Bill. Now, Bharatiya Sakshi Bill was introduced on August 11, 2023, and it aims to replace the Indian Evidence Act of 1872. So, talking about the Indian Evidence Act of 1872, it was enacted during the British colonial rule, and it establishes rules for admissibility, relevancy, and weight of evidence in Indian courts. It is applicable to both civil and criminal proceedings. It defines relevant evidence, sets criteria for admissibility, and addresses various types of evidence. The Act regulates witnesses, including competency and testimony, incorporates the hearsay rule, recognizes privileged communication, and governs opinion and expert evidence. It classifies public documents, allocates the burden of proof, includes the doctrine of estoppel, and outlines principle for determining relevancy and irrelevancy. Despite amendments and interpretations, the Act still remains a foundational document in Indian legal system, ensuring fairness in legal proceedings. Now, talking about Bharatiya Sakshya Bill, which will replace the Indian Evidence Act. This bill, like we've talked again, was introduced with the other two bills on August 11, 2023. It aims to replace the Indian Evidence Act. While preserving certain elements, it makes significant changes regarding including or the inclusion of electronic records as evidence, extending the concept of oral evidence to electronic information, broadening the category of secondary evidence, reaffirming document production provisions with exceptions and for privileged communications and addressing joint trials. The bill modernizes the evidence admissibility standards, accommodating the electronic age while retaining the core principle of the existing act. Now let's talk about the suggestions by the standing committee. So the standing committee because since that Bharatiya Sakshya Bill has largely retained the Indian Evidence Act provision, it introduced significant changes. Now, while seeing these significant changes such as introduction of electronic records as primary evidence. Now, recognizing the vulnerability of electronic evidence to tampering, the committee recommended incorporating safeguards such as secure handling and proper chain of custody for electronic and digital records during investigation. While addressing the discrepancy in admissibility of electronic evidence, the committee suggested aligning Bharatiya Sakshya Bill with clause 63, which requires certificate authentication of an electronic evidence. Now again, concerns were raised about deficiency in the certificate authenticating electronic records, prompting recommendation for amendments to meet necessary criteria for authenticity, reliability, and integrity. The committee also questioned the insertion of facts in issue in Bharatiya Sakshya Bill, recommending its deletion to maintain clarity and accuracy in legal terminology. And like the other two bills, the dissenting opinions again said that only the use of Hindi only names is violating the constitution. There has been an insufficient consultation with experts and public. Now in this particular video, the main aim was to discuss the recommendation of standing committee report. If you want to get more information about these particular bills, there has been already a video created in your Legal Darpan series itself. You can please go back and watch this for a better understanding of the current video as well. That's all from our side. Thank you so much for watching. Please like, comment and share if you like the content, and subscribe to the page. Thank you.